You spent 40 hours crafting prompts, refining outputs, selecting the best generations. You used Midjourney for the concept art, Runway for the motion, and maybe some Pika for the effects. You made thousands of decisions, curated, directed, and shaped every frame until it matched the vision in your head. You're proud of it and it's yours. You created it. But here's the uncomfortable question. Did you? Because if AI touched too many frames, if the algorithm did too much of the heavy lifting, the copyright office might look at your work and say, sorry, this isn't copyrightable. The machine made this, not you. And suddenly the 40 hours you've spent means nothing in the eyes of the law. You can't register it, you can't sue if somebody steals it, you can't license it, and you don't legally own it. So where's the line? How much AI is too much? How much human input is enough? And how do you prove that you're the author when your creative partner is an algorithm? These aren't hypothetical questions anymore. Creators are getting their copyright applications rejected right now because they didn't document their process effectively, because they didn't understand the rules, because they thought making creative decisions was enough. It's not. Legally, not yet. But there are ways to protect yourself. There are strategies to claim ownership over hybrid work, and that's exactly what we're diving into today. My name's Chris, this is AI X Visuals, and this is part 2 of protecting your work in our new AI era.
Welcome to AIX Visuals, presented by the Rift Fitters Network.
Welcome back. Today we're talking about the messy middle ground, the space where human creativity meets the machine generation, the workflow where you're directing, curating, and refining AI outputs into something that feels entirely like yours. Here's what we're covering. First, we're breaking down the new creative workflow, how modern creators are blending human direction with AI tools, and why documenting that process matters now more than you think. Then we're getting into the Copyright Office rules, what they actually said about AI-generated work, what counts as copyrightable, and what doesn't. After that, we're going to get tactical. I'm walking you through how to build proof of human authorship, logs, timestamps, edit histories, project files, the paper trail that protects you. We'll also explore the fuzzy areas where the law has not caught up yet. AI upscaling, style transfer, deep fake performances, the gray zones that are going to define the next decade of creative rights. And we'll close with some real-world scenarios. AI-enhanced indie films, CGI backgrounds from prompts, stock footage mixed with AI renders, what's protected and what's not, and how to navigate it without losing all your rights. By the end, you'll know exactly how to use AI tools while keeping legal ownership of what you create. Let's get into it. Act 1, the new creative workflow. Let's start by acknowledging what's actually happening in creative workflows right now. AI isn't replacing filmmakers, photographers, or designers. It's becoming another tool in the kit, like a camera lens or an editing plugin, except the tool is way more powerful and way less understood legally. Here's what modern hybrid workflows look like. You start with an idea, a mood, a concept, or a visual direction. Maybe you sketch it out, maybe you write a treatment. That's human and that's yours. Then you move into AI. You use Midjourney to generate some concept art based on your prompts. You feed reference images into Runway to create motion. And you use Pika for effects or Adobe Firefly to extend your backgrounds. Each tool spits out options and you select, refine, and iterate them. You are making decisions at every step. Then you bring everything into post. You composite the AI-generated elements with live footage or hand-drawn assets. You color grade, you adjust timing, you add sound. You shape the final piece into one that matches your vision. And at the end of the process, you found something that feels like it's entirely yours because it is. You made it with very creative decisions that are human. The AI just executed your instructions. But the legal problem is that the Copyright Office doesn't see it that way. Not automatically. They look at your work and ask, where is the human authorship? And if they can't see it clearly, and if it looks like an AI did all the creative work and you just press some buttons, they will reject your application. So documentation becomes everything. You need to be able to show your process. You need to prove that you were the creative driver, not the algorithm. That's harder than it sounds, especially if you're not thinking about it in the process of working. Let's talk about prompts for a second. Prompt engineering has become its own skill set, crafting the perfect text input to get the AI to generate what you want. And yes, it takes creativity, it takes language skills, literacy, iteration, refinement, but the Copyright Office has been pretty clear. Writing a prompt by itself doesn't make you the author of the AI generation. A prompt is a request, not a creation. It's like telling a photographer, I want a moody shot of a rainy street at night. The photographer takes the shot, They're the author, not you. Now, if you take that AI generated output and you significantly transform it or edit it and combine it with other elements, direct it into a larger work, then you might have some copyright claim over it, but not over the original AI output, but over your arrangement, selection, and your modifications. Think of it like a collage. You can't copyright the magazine clippings that you used, but you can copyright the way that you arrange them into something new. Your authorship is in the compilation and the curation and the creative decisions that shape the final piece. So that's the framework that you're working within. And that's why documenting your role in that process is absolutely critical, because you need to be able to point to the human decisions and say, this is where I added creative value, this is where I became the author. And without that documentation, you're just hoping the Copyright Office takes your word for it, and they won't. Act 2, the Copyright Office rules. So let's talk about what they've actually said, because there's a lot of confusion about what they've done and said, and we need to get it as clear as we can. Here's the ruling. Pure AI-generated work is not copyrightable. If you type a prompt into Midjourney and the output exactly as it comes out, you don't own that image. The AI generated, you just requested it, and the Copyright Office has clearly said that is not enough for copyright protection, because law requires human authorship. It is baked into that statute. So this is where it gets interesting. Hybrid work is copyrightable, but only for the human contributions. So if you take an AI-generated image and you paint over it, composite it with other elements, or integrate it into a larger work where you made significant creative decisions, you can copyright your contributions. Now, that doesn't mean the original AI output. That part is still not copyrightable, but your modifications and your arrangement are your creative layer on top of it, that is yours. So how do you file a hybrid work correctly? This is where most creators mess up. You can't just submit your final piece and say, I made this. You have to be transparent about what the AI did and what you did. When you fill out your copyright application, there's a section asking if the work contains material created by a third party or generated by AI. You have to answer honestly. You declare which portions are AI generated, and you describe your human contributions. You explain your creative process. And the critical part is, if you lie and you claim your work is entirely human made when it's not, your registration can be voided. And that means if you ever need to enforce your copyright in court, the defendant can argue that your registration was fraudulent, and that undermines your entire case. So transparency really isn't optional, it's legally required. Some creators are also submitting underlying files as part of their application. Project files, timelines, earlier drafts, anything that shows the progression from AI output to final work. The Copyright Office doesn't always require this, but it always helps. It gives them a clear picture of where your authorship lies. Now let's talk about some of the loopholes, or rather they should be called strategies for strengthening your claim. One thing that the Copyright Office has acknowledged is that selection and arrangement can constitute authorship. So if you separate or generate 100 images and you've chosen 10 and then arrange them into a specific sequence that tells a story, your authorship does exist within that curation. Similarly, if you generate AI footage and then edit it and adjust its pacing with sound design and integrate it with live footage, you are creating a derivative work, and derivative works are copyrightable if they involve sufficient creative input. And the key word here is sufficient. So what is sufficient? The Copyright Office hasn't given us a clear standard, and they're deciding it case by case, but generally the more that you transform the AI output, the stronger your claim will be. So here's a practical example. Let's say you use AI to generate a background plate for a scene. That background by itself is not copyrightable, but you composite it with live actors, add lighting effects, adjust the color grading to match your film's aesthetic, and then you integrate it into your narrative. Now you've got a copyrightable scene, not the background itself, but the scene as a whole. Your copyright covers the compilation, the way that you put the pieces together, the creative decisions you made in assembling and refining that final work, and that's what a total film is anyway. And that's actually pretty valuable because most creative works are compilations anyway, as I said. Films are compilations of shots, photographers use compilations of elements within a frame, and music is a compilation of notes and rhythms. So AI just makes the components easier to generate, but the authorship is still in how you use them. Act 3, building proof of human authorship. So you're using AI tools in your workflow and you want to own what you make. How do you build proof that you're the author? Here's the documentation strategy. 1. Keep your prompts, every single one. Copy them into a document, timestamp them, show the evolution of your thinking. If you iterated on a prompt 50 times to get the right output, show that in your creative decision making. That's evidence of your authorship. Save your edit history. Most AI tools don't really make this easy, but if you're working in software that tracks changes like Photoshop or Premiere, keep those project files. The revision history shows process, and it shows what you've changed, when you've changed it, and how the work has evolved under your direction. Keep drafts and versions. Don't just save the final output, save the intermediate stages, including rough cuts and early renders, and any experimental versions. Use timestamps and metadata. Make sure your files are dated. Use services like Google Drive or Dropbox that automatically timestamp uploads. If you're really paranoid, email yourself the files so you have an external record of when they existed. Document your process in writing. Keep a project journal. Write down what you did every day. Generated 20 backgrounds options in Runway, and I selected 3. Composited them with live footage, adjusted lighting in post. It doesn't have to be fancy, it just has to exist. Why does all this matter? Because if you ever have to defend your copyright in court or appeal a rejected application, you will need evidence. You'll need to be able to say that here's my creative input. Here's proof that I was a driving force. So let's talk about giving the AI credit, because some creators fear that acknowledging AI's role will lose them the copyright, when that's not actually how it works. You are supposed to acknowledge it. The Copyright Office wants transparency, but you acknowledge it as a tool, not as a co-creator. You don't list Midjourney as a co-creator, and you don't credit Runway as a collaborator. You note the AI-generated elements were used, and you describe how you transform them in your final work. Think of it like crediting your camera brand or your editing software. You're not giving Sony authorship credit for shooting on their camera, you're just noticing and noting the tools that you used. The same principles will apply with AI. Keep your pre-AI versions. If you shot live footage before throwing them into AI to enhance it, keep it. Drew sketches before AI, keep it. Anything pre-AI is fully copyrightable because it is entirely human-made, and it shows that the AI was augmenting your work, not creating it from scratch. Act 4, where the law is still fuzzy. Let's get into the gray areas, the situations where the legal frameworks have not really caught up yet. AI upscaling. You shoot a video in 1080p, and you use AI to upscale it to 4K. The AI is generating new pixels, interpolating detail that wasn't in the original footage. Is that copyrightable? Probably, because that shot was your original footage and the AI is just enhancing it. But the creative content is still yours. It's like applying a sharpening filter. The filter doesn't become the author. But what if the AI significantly changes the look? What if it adds details that weren't there, makes creative decisions about texture and color? Then it begins to get a little murkier. Style transfer is another point. Take a photograph and run it through AI, and it makes it look like a painting. The composition was yours, but the visual style is AI generated. Who's the author? Probably you, because the underlying work is yours, and the AI is just applying stylistic transformation. It's like using a filter in Photoshop. But again, the more creative the transformation, the less clear it becomes. Deepfake performances. You use AI to put your face on an actor's performance, or you generate a synthetic actor entirely. Who owns that performance? This is where it gets really complicated. If you're using someone else's likeness without permission, you've got a whole new set of legal problems. But if you're creating an entirely synthetic actor, the Copyright Office might say there's no human performance at all to copyright. You've just got an AI-generated image sequence. Performance right, likeness rights, and copyrights all start to collide here, and the law isn't really ready for it yet. Human creation as authorship. Let's say you generate 1,000 AI images that you spend weeks selecting, arranging, and sequencing them into a photo essay. Is that copyrightable? Possibly. The Copyright Office has recognized that selection and arrangement can be creative acts, but there is a threshold. You need to show that your curation involved enough creative judgment to constitute that authorship. So if you're just picking the prettiest images and putting them in chronological order, that might not be enough. But if you're creating a narrative or creating emotional flow, making intentional juxtapositions, that starts to look more like authorship in their eyes. The problem is we do not have clear standards yet, and the office itself is figuring out each one case by case. And until there are more rulings or lawsuits, legal precedents, we are all just navigating it by instinct. The best advice I can give you is this. The more human input you have and can point to, the safer you're going to be. The more you can document your creative decisions, the stronger your claim will be, and the more transparent you are about the AI's role, the less likely you are to run into problems down the line. Act 5, some real-world scenarios. Let's make it a little concrete with some real situations and answers. Situation 1, AI-enhanced indie film. You shot a film with a tiny budget, you used AI to extend the backgrounds, add visual effects, and enhance the cinematography. Who owns the visuals? You do. You shot the original footage, you directed the actors, you made the creative decisions about framing and composition. The AI filled in the gaps. As long as you document what you did and what the AI did, you've got a strong copyright claim over the final film. Scenario 2, CGI backgrounds from prompts. You're creating an animated short and you use AI to generate background environments based on detailed prompts, and you composite characters on top of them. The characters are yours if you created them. The backgrounds by themselves probably are not, but the final composite and the way you arranged everything, that is going to be copyrightable. Your copyright covers the scene as a whole, even if individual elements are not protectable. Scenario 3, stock footage mixed with AI renders. You licensed some stock footage and then you used AI to modify it or extend it. Who has that license? You need to check the stock footage license terms because some explicitly prohibit that their footage be used to train AI models or create any derivative works with that AI. If the license allows modifications, you're still probably okay, but your copyright only covers what you added. The original stock footage is still owned by the stock provider and you have been licensing it. Scenario 4, disputed authorship. You collaborated with another creator and they claim they made all the creative decisions and that you just ran the prompts. How do you prove otherwise? This is where documentation is going to save you, and if you kept logs and drafts, you'll be able to communicate and show your creative input. You can defend yourself. If you didn't, it's your word against theirs, and that's a really bad position to be in. Contracts matter here too, and before you ever start collaborating, agree in writing who owns what. Who's the author, who's the assistant, and how work will be credited and copyrighted. Get it clear up front. These scenarios aren't really edge cases anymore, and they're happening right now. And the creators who are more prepared and documented in their process and who understand the rules are the ones who are going to come out on top in the future. So in closing, here's the bottom line. You can use AI and you can integrate it into your workflow. You can let it handle the tedious stuff and generate raw materials and speed up your process. That's fine because that is the future. But you have to stay in the driver's seat, creatively and legally. You have to make decisions, add value, and transform the outputs into something that actually reflects your vision. And you have to document it because the law isn't just going to take your word for it. The Copyright Office needs proof. Courts need evidence. And you can't show that you were the creative force and you're going to lose the claim if you can't. You can't copyright the model. You can't own the algorithm, but you can copyright your mind's input, your direction, your curation, and your transformation. That's where authorship is going to live in the age of AI. So keep your logs and save your drafts. Be transparent in your applications and build a paper trail that proves you're the creator, not just the prompter. Human hands still matter. Human decisions still matter. And as long as you can prove that you were driving the process, you can own what you make. And I hope that you were authentic in your explaining to the Copyright Office what you really made, because it's important to actually contribute to the future of how we create in this AI era. Every piece and every copyright that you submit is helping us decide how all of this is going to be going forward into the future. So in closing, I'd like to leave you with one question that I hope you can answer for me. Where do you personally draw the line between AI assisted and AI generated? At what point does the algorithm's contribution become too much for you to claim ownership? Please leave your thoughts in the comments and please follow and subscribe for more content that helps artists like you walk through the ever-changing landscape that is AI and technology. Thanks for watching AIX Visuals, and we will see you next time.
That was AIX Visuals, presented by the Rift Fitters Network. Thank you for listening, and please remember to subscribe for weekly updates that keep filmmakers and visual artists like you informed in the new era.